Imagine a courtroom, stern-faced judges, bewigged lawyers, anxious witnesses, a scene familiar from countless historical dramas. But now, picture the defendant, not a hardened criminal, not a cunning thief, not even a rebellious peasant. No, in the dock stands a pig, or perhaps a rooster, or maybe an entire swarm of locusts. It sounds like something out of a surreal Monty Python sketch, doesn't it? Yet, for centuries, primarily during the Middle Ages and into the early modern period, this was a startling and very real judicial practice across parts of Europe. Animals, and even inanimate objects, were formally accused of crimes, provided with legal defense, tried in ecclesiastical or secular courts, and, if found guilty, sentenced to punishments ranging from excommunication to public execution. Welcome, truth seekers and explorers of history's strangest corners, to HistoryVerse X. Tonight, we delve into one of the most bizarre, most perplexing, and frankly, most darkly comical chapters in legal history, the astonishing world of medieval animal trials.
The very notion strikes us today as absurd. How can an animal, lacking human reason or moral understanding, be held criminally responsible for its actions? Yet, to understand this peculiar phenomenon, we must immerse ourselves in the medieval mindset, a worldview profoundly different from our own. One where the boundaries between the natural, the human, and the divine were far more porous, far more interconnected. These weren't informal acts of mob justice against a troublesome beast. Oh no, these were formal legal proceedings, often meticulously documented, adhering to the established judicial procedures of the time. Animals were arrested, imprisoned, sometimes even tortured to extract confessions, though this was rarer and more controversial. They were assigned lawyers, whose job it was to mount a vigorous defense, arguing extenuating circumstances, mistaken identity, or even demonic possession. Witnesses were called, evidence was presented, and learned judges deliberated before passing sentence. And the sentences could be severe. Pigs found guilty of harming or killing humans, especially children, whom they might encounter in less supervised medieval households, were frequently hanged, burned at the stake, or buried alive, often dressed in human clothes as a final, grotesque mockery. So, why? Why did medieval societies expend such effort, such legal formality, on prosecuting creatures that, to our modern sensibilities, were simply acting on instinct? What does this tell us about their understanding of justice, of responsibility, of God's order, and the very nature of the world around them? If you're ready to step into a courtroom where the defendant might oink, crow, or buzz, then prepare yourselves. And if you find these historical oddities as fascinating as we do, remember to show your support. Hit that like button, subscribe to HistoryVerse X for more explorations of the extraordinary, and ring that notification bell so you don't miss a single strange verdict.
To grasp the logic, however alien, behind animal trials, we must first understand the intellectual and spiritual landscape of the Middle Ages. This was a world steeped in religious belief, where God's presence and intervention were seen in every aspect of life. The natural world was not a neutral, scientifically explicable space. It was God's creation, imbued with divine order, and also susceptible to the machinations of the devil and his demonic minions. In this context, a destructive act by an animal, a pig goring a child, a swarm of locusts devastating crops, even a rooster crowing at an unusual hour, sometimes seen as an ill omen or a demonic sign, wasn't just an unfortunate natural event. It could be interpreted as a disruption of God's order, a sign of divine displeasure, or even direct evidence of satanic influence. The animal itself might be seen as an instrument of evil, possessed by a demon, or acting under diabolical command. Therefore, bringing the animal to trial was, in a sense, a way to restore that divine order, to publicly identify and purge the evil, and to reaffirm the community's adherence to God's law. The legal process itself, with its rituals, with its pronouncements, and its ultimate judgment, served as a powerful public spectacle. It was a form of communal catharsis, a way of making sense of misfortune and reasserting control in a world that often felt chaotic and unpredictable.
Another key factor was the medieval tendency to anthropomorphize animals, to attribute to them human-like qualities, including a degree of moral agency. This is evident in the popular beast fables of the time, like the stories of Reynard the fox, where animals talk, scheme, and exhibit distinctly human virtues and vices. If animals could be portrayed in literature and art as possessing cunning, malice, or loyalty, it wasn't such a huge leap for some to believe they could also be held accountable for their crimes in a more formal setting. Furthermore, medieval law itself was a complex tapestry, drawing from Roman law, Germanic customary law, and burgeoning canon law. Some legal traditions did, in a limited way, recognize a form of legal personhood, or at least legal standing, for non-human entities, especially when property or community well-being was at stake. For instance, if a pig, which was valuable property, caused damage, its owner could be held liable. The trial of the pig itself, rather than just its owner, might have been seen as a more direct way of addressing the offending party and symbolically cleansing the community of the transgression. It's also important to distinguish between two main types of animal trials. Secular courts typically dealt with individual animals, mostly domestic ones like pigs, horses, dogs, bulls, accused of harming humans or property. These often resulted in capital punishment. Ecclesiastical, church courts, on the other hand, more frequently dealt with vermin, swarms of insects, rats, weevils, field mice that damaged crops or caused widespread nuisance. The punishments here were often different: anathema, a formal curse; excommunication from the church, yes, for insects; or a stern order to depart the afflicted region by a certain date.
The historical records, though fragmented, provide us with some truly astonishing examples of these animal trials. One of the most infamous is the case of the Pig of Falaise in Normandy, France, in 1386. This unfortunate sow was accused of horrifically mutilating and killing an infant. The pig was arrested, imprisoned in the local jail, reportedly alongside human prisoners, and then brought to trial before the Viscount of Falaise. The proceedings were conducted with all due legal formality. The pig was even dressed in human clothes, a waistcoat, gloves, and drawers for its public execution in the town square. It was first maimed in the head and forelegs, mirroring the injuries of its victim, and then hanged. The executioner was paid for his services, including a new pair of gloves for handling the condemned beast, and the event was recorded in detail, a grim spectacle for the townsfolk. This was not an isolated incident. Numerous records exist of pigs being tried and executed for similar offenses across Europe. In 1457, in Savigny, France, a sow and her 6 piglets were accused of murdering a 5-year-old boy. The sow was found guilty and hanged. The piglets, however, were acquitted, largely due to the impassioned defense of their lawyer, who argued for their youth and the bad example set by their mother.
Bulls that gored people, horses that kicked or trampled individuals, even dogs involved in attacks could all face the full rigor of the law. The intention was not just punishment, but a public demonstration that such transgressions, even by animals, would not be tolerated and that order would be restored. Sometimes the crimes were less about direct harm to humans and more about perceived violations of the natural or divine order. Consider the bizarre case of the Rooster of Basel, Switzerland in 1474. This unfortunate fowl was accused of the heinous and unnatural crime of laying an egg. In medieval folklore, a rooster laying an egg was considered a deeply ominous sign, an act against nature, and it was widely believed that such an egg, if hatched, would produce a fearsome creature known as a cockatrice or basilisk, a serpentine monster capable of killing with its gaze. So, the rooster was arrested, put on trial in an ecclesiastical court, and, despite the eloquent arguments of its assigned lawyer, who presumably questioned the biological feasibility of the charge, it was found guilty. The sentence? The rooster, along with the offending egg, was publicly burned at the stake as a sorcerer in league with the devil. Then, there were the trials involving swarms of pests. These fell under the jurisdiction of the church courts. If a region was plagued by locusts, caterpillars, weevils, or field mice devastating the crops, the community might appeal to the bishop.
The ecclesiastical court would then initiate proceedings. A lawyer would be appointed to defend the pests. Another lawyer would act as prosecutor on behalf of the afflicted human community. The pests would be formally summoned to appear in court, often by a public crier reading a summons at the edge of the infested fields. Naturally, the insects or rodents rarely, if ever, made a personal appearance. If, after due process, the pests were found guilty of their destructive behavior, the church might issue a formal anathema, a curse condemning them, or an order of excommunication, effectively banishing them from the Christian community and, it was hoped, from the afflicted lands. Sometimes a specific time frame was given for their departure, with further spiritual sanctions threatened if they failed to comply. One famous case involved weevils in a vineyard in Saint Julien, France, in 1587. The trial dragged on for months, with postponements due to bad weather, preventing the weevils from traveling to court, or so it was argued. The weevil's lawyer argued passionately that his clients were merely exercising their God-given right to sustenance. The outcome? The court, in a rather Solomonic compromise, eventually ordered that a separate plot of land be set aside for the weevils, provided they agreed to leave the main vineyards untouched. Whether the weevils honored this legal agreement is, alas, not clearly recorded.
The fact that animals were assigned legal counsel is perhaps one of the most astonishing aspects of these trials. These were not token appointments. Lawyers like the famous Bartholomew Chassigny in 16th century France gained renown for their skillful, if somewhat surreal, defense of animal clients. Chassigny, for instance, famously defended rats accused of destroying barley crops in autumn. When the rats failed to appear for their first court summons, Chassigny successfully argued that the summons had not been properly served to all his clients, given their widespread and somewhat elusive nature, and that they deserved more time, as many were young, old, or infirm, and the local cats posed a significant threat to their safe passage to the courthouse. He managed to delay proceedings considerably with such ingenious arguments. The defenses offered in these trials could be remarkably creative. Provocation. It might be argued that the animal was provoked or was merely defending itself or its young.
Duress or demonic influence. The lawyer might claim the animal was not acting of its own volition, but was compelled by a demonic force, thus shifting blame. Youth or lack of discretion. As with the Savigne piglets, the youth of an animal could be a mitigating factor. Natural instinct. For pests, lawyers would argue they were simply following their natural, God-given instincts to eat and survive. Benefit to the community. Counterintuitive. In one case, involving Spanish flies, blister beetles, damaging crops, the defense argued that the beetles were also used for medicinal purposes, as an aphrodisiac and skin irritant in medicine of the time, and therefore provided a net benefit. Witnesses, both human and sometimes, symbolically, animal, could be called. Evidence, such as the damaged crops or the wounds on a victim, would be presented. The entire affair, however bizarre to us, was conducted with an air of solemn legal gravity.
The public nature of many of these trials, particularly the executions of larger animals, cannot be understated. These were not quiet affairs conducted behind closed doors. They were community events, spectacles designed to reinforce social norms and divine order. The execution of a pig, dressed in human clothes and hanged in the town square, served as a powerful, visceral warning. It was a dramatic assertion of human dominion over the animal kingdom, and a public ritual of purging perceived evil or disorder.
Even the ecclesiastical trials of pests, with their public summonses and pronouncements of excommunication, had a performative aspect. They offered the community a sense of agency, a feeling that something was being done to combat the forces that threatened their livelihoods, even if those forces were a swarm of caterpillars. These trials also provided a framework for dealing with loss and misfortune. In an age before scientific explanations for crop failures or sudden deaths, blaming a bewitched animal or a plague of insects sent by an angry god offered a kind of explanation, a target for communal anxiety and action. The legal process, however strange its application, provided a structured, ritualized response.
So, what happened to this peculiar legal tradition? Why don't we see pigs in the dock today? The practice of formally trying animals began to decline significantly from the 17th century onwards, though isolated cases occurred even later. This decline was driven by profound shifts in European thought and worldview. The rise of scientific rationalism, the scientific revolution, spearheaded by figures like Galileo, Newton, and Descartes, ushered in a new way of understanding the natural world. Emphasis shifted towards empirical observation, natural laws, and mechanical explanations. Animals came to be seen more as biological organisms governed by instinct, rather than moral agents susceptible to demonic influence. René Descartes famously described animals as mere automata, complex machines without souls or true consciousness. This view, while controversial, made the idea of holding them legally culpable increasingly untenable.
Changes in legal philosophy. Legal systems themselves were evolving. There was a growing emphasis on intent, mens rea, as a crucial element of a crime. Since animals were not deemed capable of forming criminal intent in the human sense, the basis for their prosecution eroded. The focus of the law shifted more towards the responsibility of human owners for the actions of their animals. The Enlightenment. The 18th century Enlightenment, with its focus on reason, individual rights, and humanitarianism, further distanced society from what came to be seen as the superstitious and barbaric practices of the past. Animal trials increasingly looked like relics of a darker, less rational age. While the formal trials faded, the underlying human tendency to blame or seek retribution against animals that cause harm hasn't entirely disappeared, though it now manifests in different, less ritualized ways. The medieval practice of putting animals on trial stands as one of history's most fascinating and, to our modern eyes, utterly bizarre legal curiosities. It offers a unique window into a mindset profoundly different from our own, a world where the sacred and the profane, the natural and the supernatural were deeply intertwined, where justice was not just a human concern, but something that, it was believed, extended to all of God's creation, albeit in ways we now find perplexing.
These trials were more than just absurdities. They were a reflection of a society grappling with misfortune, seeking order in a chaotic world, and attempting to understand its place within a divinely ordained cosmos.
They highlight the human need for explanation, for ritual, and for a sense of control, even when faced with the seemingly inexplicable actions of the non-human world. While we may chuckle at the image of a lawyer passionately defending a group of weevils or a pig dressed for its own execution, these strange proceedings remind us that legal systems and our understanding of justice itself are not static. They evolve. They reflect the changing beliefs and values of the societies that create them. The echoes of these animal courtrooms, though faint, still linger in the historical record, a peculiar testament to a time when the very beasts of the field and the pests in the crops could find themselves facing the full and often fatal majesty of the law. I hope this journey into the peculiar world of medieval animal trials has not only intrigued you, but perhaps also offered a moment of quiet contemplation on the ever-shifting landscape of human belief and justice. The past is indeed a foreign country. They do things differently there. Good night, and may your own encounters with the animal kingdom be significantly less litigious. Until next time, here on HistoryVerse X.